Today, we are learning brand new information about the president's legal defense and who will make the case at trial. One name you may recognize, Alan Dershowitz, will help make the case defending the president. The New York Times, the Washington Post, and NBC all reporting Alan Dershowitz will be joining Trump's legal team. Dershowitz posting today about his, quote, oral arguments that will be offered. Alan Dershowitz is a Harvard Law School professor emeritus and one of the most preeminent criminal defense attorneys in the nation, having tried over 200 cases. He joins me now via Skype at a busy time. Thank you for being here, sir.
Thank you. It's 250 appeals. I'm not actually a trial lawyer. I've only tried a small number of cases. I'm an appellate and constitutional lawyer.
250 appeals cases and effective
right.
when you're in the courtroom. Let's get into what you're doing. President Trump publicly admitted that he wanted Ukraine to investigate the Bidens. Will you and this team argue that the president can legally condition that kind of request on foreign aid?
Let me be very clear what my role is. I will not be involved in the factual aspects of the case, in tactical issues about whether to call witnesses. My sole responsibility is to analyze and present the constitutional arguments against impeachment based on the two articles of impeachment. I will present the history of the constitutional impeachment provisions, the history of the impeachments that have gone on, the three in our history, and make a broad argument. I'm not a full-fledged member of his legal team in the sense that I have a limited role. I will appear one day in the Senate. I'm not part of the kind of tactical or strategic
What
team.
argument will you make that the Constitution supports what the president, as I mentioned, has publicly admitted, or in addition, what he's been accused of?
It's not a question of what the Constitution supports. It's what the Constitution requires or prohibits. The Constitution sets out 4 criteria for impeachment: treason, that's not been charged; bribery, that's not been charged; or other high crimes and misdemeanors. And the high crimes and misdemeanors are obstruction of Congress, which is completely made up. The president invoked his executive authority, separation of powers, checks and balances. That's an extremely dangerous article of impeachment. And the other one, abuse of power. Virtually half of American presidents, from Adams to Jefferson to Lincoln to Roosevelt, have been accused of abuse of power. And the framers explicitly rejected those kinds of broad, open-ended criteria. They were fearful that it would empower Congress to turn the presidency into the prime ministership of England, where the prime minister can have his tenure ended by a simple vote of no confidence. That's not what the framers wanted. They wanted specific criteria for impeachment, and none of those criteria, in my view, have been met, and I will lay out that argument.
Well, how do you make that argument, though, without dealing with some of these facts, right? I mean, certainly one could imagine an abuse of power that would meet the standard. I'm sure you and I would agree on that in theory. And so the abuse
we don't agree on that.
We don't agree on that? Well, let me play for you, sir. Let me play for you and then get your response. Let me play for you the president admitting the investigation, then I'll get your response on whether that's an abuse.
Okay.
Here's Donald Trump on the White House lawn.
Mr. President, what exactly did you hope Zelensky would do about the Bidens after your phone call? Exactly.
Well, I would think that if they were honest about it, they'd start a major investigation into the Bidens.
The abuse of power allegation is that request, conditioned on money that was federally mandated under the law for a different purpose, is the abuse.
Well, but abuse of power, even if proved, is not an impeachable offense. That's exactly what the framers rejected. They didn't want to give Congress the authority to remove a president because he abused his power. They have to prove treason, they have to prove bribery, or they have to prove other crimes and misdemeanors. Other refers to crimes of the kind such as treason and bribery.
Interesting. So let me make sure I understand for viewers, because you're making news here about what you will argue on the president's behalf in the Senate trial. The news you're making, as I understand it, is that, quote, abuse of power, in your argument, does not constitute as a high crime under the Constitution?
That's exactly right. And that's exactly what the framers said when they rejected. Remember, the initial criteria for removing a president was maladministration, malpractice, and a range of other kind of vague, open-ended criteria. And what Hamilton said is the greatest danger would be to empower Congress to impeach based on how many votes you have on one side or the other. That's why after they finished debating whether there should be an impeachment, they went to the criteria. And Madison, who was very much in favor of impeachment, wanted very limited criteria. And if they wanted to put abuse of power, and they could have. Let me give you another example. Madison talked a lot about what if a president becomes incapacitated. But they didn't put incapacitation as a ground for impeachment. We had to amend the Constitution to do that. If you want to amend the Constitution to have abuse of power as a criteria, you can do that. Nobody will vote for it, though,
well, and
because presidents have accused of abuse of power from the beginning of time.
Very interesting getting your expertise in what you plan to argue on the president's behalf. I also want to play for you something that would seem to also create high crimes problems, which is Mr. Giuliani, who is not currently publicly slated to be a part of the team that you're on arguing in the Senate, has been out there saying the president sent him off to do these things abroad. Some of these things, at least the impeachment managers, the Democrats argue, are crimes. Take a listen to how that conflicts with what the president has said. Here we go.
What was Rudy Giuliani doing in Ukraine on your behalf?
Well, you have to ask that to Rudy, but Rudy, I don't even know. I know he was going to go to Ukraine.
So you didn't direct him to go there on your behalf? You
No.
didn't.
The narrative right now is that you looked into Ukraine because Biden was running for president.
Complete lie. I looked into Ukraine because it was thrown at me, put in my lap.
Does it matter that they're contradicting each other? And does it matter if the president did direct Giuliani, as he has said publicly, to do anything abroad that might involve a high crime or a federal felony?
Well, sure, it matters for when you decide who to vote for. I voted for Hillary Clinton. I'm a liberal Democrat, and all of these things will influence my decision who to vote for. But none of them rise to the level of high crimes and misdemeanors. If you wanted to charge him with a crime, that's what they did in the Clinton impeachment. They charged him with specific crimes, and that's what they did with Nixon. But they didn't. Here, they haven't charged them with specific crimes as part of the articles of impeachment, just 2 articles of impeachment, abuse of power and obstruction of Congress. Neither of those rise to the level of constitutional offenses. It's not just a question of drafting. It's a question of what the senators have to vote on. The senators vote yay or nay. Did the president abuse his power? And did the president obstruct Congress? And those are not constitutionally permissible criteria.
And Professor, when you make this claim, which you're previewing what the Trump trial strategy will be, so I'm sure a lot of people...
Let me be very clear.
Well, let me ask you a question, and then we'll get into that point. When you make this argument, a lot of people are listening. I was saying that in a good way. It's quite relevant and newsworthy. Right. Will you then have to argue against some of the founders and some of the Federalist Papers that do talk about abuse of power being impeachable? Federalist 65 says abuse of the public trust is the type of thing that you can impeach an officer for.
Of course, I will take that on, and of course, you're totally and completely and 100% wrong. That's not what Federalist Paper 65 says. What Federalist Paper 65 says is that if you look at the criteria for impeachment, treason, bribery, high crimes, and misdemeanor, those are crimes that involve the public and they are political in nature. That's very different than saying that abuse of power by itself is a criteria for impeachment. There is a great confusion between whether to impeach, which was a great debate, and people use terms like abuse of power in the decision whether to impeach. Then they came to a very different decision, what the criteria should be. Right. And then Madison, who was very hawkish on impeachment, became very dovish when it came to the criteria, because he didn't want to give Congress the authority.
I'm not sure that a question itself can be 100% wrong, because a question seeks information. You're providing it, and I appreciate it.
The premise of the question was questionable.
But the premise of the question was questionable, and I appreciate your criticism.
A lot of people.
You've been on the beat before, and in the time we have, I did want to show history here. When we had you on and you were discussing some other issues, we did ask about whether you did or would defend the president legally to join his team. Take a look.
Right. Sure.
Have you provided any formal counsel to Donald Trump or his aides, or accepted any money, or would you consider providing counsel to them?
What an insulting question. I mean, have I accepted money? I'm a liberal Democrat.
I take it that's a no.
Please don't try to insult my integrity by suggesting that somehow I'm in somebody's pocket.
But you're a very celebrated attorney who's taken on a lot of different cases. Is that a no, that this is not a case you would consider at this time?
I'm a civil libertarian. Sometimes my statement helped Democrats, sometimes it helped Republicans.
Not only is it not insulting, it's now what you're doing. You are going to argue on behalf of the president and the Senate in this trial.
Let me be very clear. I'm arguing on behalf of the Constitution. I'm arguing to avoid a terrible precedent being set for future presidents. I am not somebody who is strategizing with his legal team. I won't be involved in the decision whether to call witnesses. I won't be involved in facts. What I'm doing is precisely consistent with what I've said. I'm standing up for what I believe is the proper interpretation of the Constitution. I'd be doing the same thing if Hillary Clinton had been elected.
But you will be doing it as a lawyer for President Trump.
I am doing it as a lawyer. I am doing it as a lawyer who is not in a lawyer-client relationship with anybody. I am presenting the constitutional argument that, in this case, happens to help President Trump.
But let's be clear, because everyone's watching this in America, Professor. By what authority would you step out on the Senate floor? Witnesses have not been cleared. The only people on the floor are the senators and the counsel for both sides, the impeachment managers and the president's lawyers.
I am part of the legal team with a very specialized role. My specialized role is to present the constitutional argument, the same argument I would present if Hillary Clinton had been elected and she were being impeached, the same argument I presented in 3 books and maybe 35 or 40 articles. And so I fully intend to be presenting an argument basically on behalf of the Constitution. Yes, the person being impeached and being removed is President Donald Trump, who I voted against. But I'm trying to present a very nonpartisan view of the Constitution. And I think it'd be refreshing to have a nonpartisan view introduced on the Senate floor in this highly partisan impeachment and removal. So I'm proud to be presenting a nonpartisan view of the Constitution.
Professor Dershowitz, we've always appreciated having you on in the past and now and hearing about your views of all of this. I appreciate your time, sir.
Thank you.
Thank you. And we should mention your new book is The Case Against Removing Trump. That's out now. I want to turn to some more experts to give us context and commentary. MSNBC legal analyst and former civil prosecutor Maya Wiley, and Drew Findling, who is a former president of the National Association of Criminal Defense Lawyers and has an extensive understanding of how you defend individuals at trial, even when there might be all kinds of evidence there. Great to have you both here.
Great to be here.
Maya, what did you think of the professor's remarks?
I thought they were incredible. And what I mean by that is that there are a large number of constitutional scholars. We heard 3 of them testify before the House Judiciary Committee who said abuse of power is absolutely something that a president can be impeached for. And by the way, the 4th constitutional scholar, who was called by the Republicans, John Turley, also conceded that a president could be impeached for abuse of power. His argument was that there was insufficient evidence, which is a different argument from Alan Dershowitz.
And yet Professor Dershowitz is surfacing something that we know for a fact, that's why he's so nervous with it, it will come up at this high-stakes trial, which is there was a debate over whether to include bribery. Viewers of this show know that we discussed that, reported on it, and they went with abuse of power. He says that there is absolutely no way to support abuse of power. As you mentioned, there is, and there's text on that. But is it interesting to you, given his real experience in courtrooms, that he's seizing on that and he wants to make this a high sort of constitutional textual debate about maybe you picked the wrong thing. Maybe it's not even a high crime.
Well, as a strategy, I think it can help serve the argument that these aren't impeachable offenses if it turns to being an evidentiary standard, which I would find ironic because we have an obstruction. I also found that argument, implausible, that, a president can assert executive privilege over every single shred of everything in government and yet somehow not be obstructing Congress when that's not even the way the privilege functions.
And then briefly, before I turn to Drew, I'm curious, because we've been through so many of these stories together, Maya. What did you think, Professor Dershowitz, who I know does things for a reason and has a strategy, what is his interest and emphasis on trying to distinguish his role? I mean, we got him to finally concede he will be going out on that floor as a Trump lawyer. There's no other people allowed. There's no guests. There's no +1s at the Senate trial. But what is he getting at there and trying to say he's different than the other lawyers somehow?
Well, I think it's two things. I think, one, there is some liability to having an Alan Dershowitz as your defense attorney because he's been implicated in, not implicated in the sense of being charged. Just want to be clear. I'm not saying there's sufficient facts. But Alan Dershowitz is someone who is implicated in some relationship with Jeffrey Epstein.
Which is a big controversy for the administration.
Big controversy for the administration, not a good look. But it's also, just one last point quickly, it's also that it enables him to be seen as an independent analyzer of
which is an argument he's making when, in fact, he will be a zealous advocate. Your view?
Well, there's just too much to comment over. And I look at it as a trial attorney, and I look at Alan Dershowitz speaking and think about how he would be cross-examined. And he ended by talking about how partisan the proceedings have been to date. That shows that he's walking into this with a political opinion. Secondly, he has a book on this subject. If he were going to be cross-examined by a real trial lawyer, he would be eviscerated because of those two things. Secondly, he knows the federal rules. He understands that there's a thing called abuse of trust. And there are a lot of people, particularly former politicians, in jails all over America, particularly federal jails, because of abuse of trust, and he knows that. And the last thing that he is well aware of is what we call 404B, and that is past acts.
Prior bad acts. And he has got to walk into his analysis and say, when you're the president of the United States, you have to think you have an understanding of Article 2 of the United States Constitution. So he needs to look at the president and all his activities in the past and see whether he's exhibited an understanding of what's constitutionally permissible and what is not. And he was a lawyer who said he didn't want to get into the facts because he's going to be doing that other type of argument. We've got to fit in a break. We went long with all this. Drew, Maya, thank you so much. We have a lot more tonight.